Hello everyone and welcome back to the channel. If you're into Nigerian politics, opposition parties, or just want to understand how our courts actually shape the game ahead of 2027, you are in the right place. On 30th April 2026, the Supreme Court of Nigeria delivered a judgment that has everyone talking about the African Democratic Congress, the ADC. The Cable and other outlets reported it. The Apex Court has remitted the leadership dispute back to the Federal High Court for a full substantive hearing, while voiding the Court of Appeal's earlier status quo ante Bellum. But what does this actually mean? Is it a full victory for former Senate President David Mark or just a temporary breather? Today, we are breaking it down in simple, everyday language. No legal jargon without explanation, no hype, just clear facts, real examples, and what it means for the party, INEC, and Nigerian democracy. Stick with me till the end because this isn't just about one small party. It is about how courts referee political fights in Nigeria. Before we dive in, like, share, and subscribe. The headline in plain English. First, let's state exactly what the Supreme Court did today. In an unanimous decision by a 5-man panel led by Justice Mohammed Lawal Garba, the Supreme Court set aside, that is, they vacated or cancelled the order from the Court of Appeal that had forced everyone to maintain status quo ante Bellum. At the same time, they did not finally decide who is the real chairman of the ADC. Instead, they sent the entire main case back to the Federal High Court in Abuja before Justice Emeka Nwite for a proper, full hearing on the real issues. Think of it like this. Two groups are fighting over who controls the family house. One group gets a temporary court order saying nobody touch anything until we sort it out properly. The Higher Court looks at that temporary order and says that freeze was too broad and not needed at this stage. Lift it. But the actual ownership fight, go back downstairs to the first court and argue it fully with all your evidence. That is what happened here. No final winner declared yet on the leadership, but the temporary paralysis has been removed. Many analysts say this gives the David Mark-led executive with Rauf Aregbesola as National Secretary immediate breathing space to operate with INEC and run party affairs. What on earth is status quo ante Bellum? This Latin phrase caused a lot of confusion. Let's break it down like we are explaining it to a friend over a coffee. Status quo means the existing state of things, how everything is right now. Ante Bellum means before the war, before the conflict started. Put together, restore things to the way they were before the fight broke out. In the ADC case, the Court of Appeal on March 12, 2026 ordered that parties should maintain this pre-dispute situation. But here's the problem. What exactly was the before movement? Before Rauf Aregbesola, former long-serving chairman, handed over to David Mark in July 2025, before Nafiu Bala Gombe went to court to challenge the transition or some other points in the party's history. Different people read it differently. INEC, trying to stay neutral, basically hit pause on recognizing the David Mark-led team on their portal. They stopped accepting official documents from either side to avoid being accused of taking sides. This created a practical leadership vacuum. The party couldn't easily hold recognized meetings, plan congresses, or prepare structures for elections. It was like the car was stuck in neutral while the engine was running. The Supreme Court looked at this broad interim order and ruled it was unnecessary, improper, and unwarranted at that stage. They said the appeal court went beyond what was needed for dismissing parts of the appeal. By voiding it, the Apex Court has effectively lifted the administrative freeze. Real world example. Imagine a company boardroom fight. A lower court says freeze all bank accounts and stop all decisions until trial. The higher court says that is too extreme. Unfreeze the accounts so the business doesn't collapse, but still go to trial to decide who really runs the company. That is the spirit here. The party can now function again, at least provisionally. How did this crisis even start? Full background. To understand this judgment, we need the full story, no shortcuts. The African Democratic Congress, ADC, is one of Nigeria's registered opposition parties. It has been relatively small but gained attention as a potential platform for broader opposition realignment ahead of 2027 key events. For over 20 years, Chief Rauf Aregbesola served as national chairman. In July 2025, around July 2nd or 29, depending on reports, Nwosu announced his resignation or transition at an event in Abuja. He reportedly issued membership cards and handed over leadership to a new interim National Working Committee led by Senator David Mark as national chairman and Ogbeni Rauf Aregbesola, former Osun State Governor, as national secretary. This move was positioned as bringing experience and strategy to reposition the ADC as a serious alternative. David Mark, a former Senate president with military background and decades in politics, and Aregbesola, known for his organization skills, were seen as heavyweights. However, not everyone agreed. Nafiu Bala Gombe, who had been a former deputy national chairman or vice national chairman, challenged the transition. He argued it violated the party's constitution, issues around proper consultation, tenure limits, internal processes, or even whether it amounted to a hijack. Gombe filed a suit at the Federal High Court in Abuja, suit marked FHC/ABJ/CS/1819/2025, naming the ADC, David Mark, Rauf Aregbesola, Rauf Aregbesola, and INEC as parties. He sought to restrain the Mark-led group from parading themselves as leaders and to affirm his own claim or restore a previous status. Timeline highlights: September 2025, Federal High Court makes some rulings, including an ex parte, one-sided applications. Mark side appeals certain decisions. March 12, 2026, Court of Appeal delivers judgment, dismisses parts of the appeal, and adds the status quo ante bellum directive. INEC, relying on that order, delists and stops full recognition of the Mark executive on its portal. This paralyzes normal party administration. Mark's faction appeals to the Supreme Court, appeal number CS-CV 180/2026 or similar, arguing among other things that the appeal court overreached and that many party leadership issues are internal affairs where courts should be cautious. April 22, 2026, Supreme Court hears arguments. April 28, 2026, Mark-led ADC even writes to the Chief Justice urging speedy judgment to avoid missing electoral timelines for 2027. April 30, 2026, judgment delivered. The core questions in the substantive suit include: did the transition follow the ADC constitution? Was there proper internal democracy? Are there tenure violations? And crucially, how much should courts interfere in internal party affairs in quotes? Important legal ideas made simple. Nigerian courts have a long-standing principle. Political parties are private voluntary associations. Purely internal matters, like who becomes chairman through internal elections or conventions, are often non-justiciable, meaning courts prefer not to interfere unless there is a clear breach of the party's own constitution, the Electoral Act, or fundamental rights, like fair hearing. However, when disputes affect public interest, such as who can validly submit candidates to INEC or control party structures for elections, courts do step in. Section 223 of the 1999 Constitution and parts of the Electoral Act emphasized internal democracy in parties. In this case, the Supreme Court is emphasizing due process. Don't use interim orders to effectively decide the case prematurely. Let the trial court hear evidence, call witnesses if needed, interpret the party documents, and deliver a reasoned judgment on the merits, the actual substance. Remitting the case means sending it back for that full hearing. The trial judge can now proceed without the shadow of the broad appeal court order hanging over everything. The court also touched on an ex parte order regarding service of processes but allowed the main appeal in part by setting aside the status quo directive. Another real example for context: remember the prolonged PDP leadership crisis involving Ali Modu Sheriff versus other factions in past years. Courts allowed hearings on leadership but were careful not to micromanage every internal convention. Similarly, various APC state chapters have seen court interventions when statutory provisions were allegedly breached. Today's ruling leans toward judicial restraint on wide interim orders that can paralyze institutions while still ensuring grievances get a full day in court. Immediate practical effects. Who wins today? Short term. The David Mark-led faction gains significant operational relief. With the status quo order lifted, INEC will likely review its position and restore functionality so the recognized leadership can interface officially, issuing letters, planning structures, etc. Reports already describe this as restoring the Mark-led executive provisionally. The party can move forward on internal organization without total paralysis. This is crucial because 2027 preparations, membership registration, congresses, potential coalitions have deadlines. But let's be clear and balanced. This is not a final victory for David Mark-led faction, no. The substantive suit by Nafiu Bala Gombe returns to the Federal High Court. That court could still rule in favor of Gombe's claims, declare the transition invalid, or even find that certain issues are internal and decline deep interference. Further appeals could follow if parties are dissatisfied. Some reactions on social media already shows this split. Supporters of Marx celebrate restoration and stability for opposition building. Critics say premature celebration, the real fight continues at the trial court. Others worrying about ongoing uncertainty hurting the party's chances. INEC's role is delicate. As the regulator, they must remain neutral but need clear judicial direction to perform administrative duties. The delisting was tied to the now voided order, so expect adjustments soon. Why should you care if you are not an ADC member? Opposition health matters. A functional multi-party system keeps the ruling party accountable. Prolonged leadership crisis in parties like ADC, PDP, NNPP, or Labour Party weaken alternatives and breed voter apathy. Secondly, rule of law and judicial balance. This judgment shows courts correcting overreach on interim measures. Vague or overly broad orders can cause more harm, economic or institutional paralysis than good. Clearer, more precise directives help everyone, parties, regulators, and the public. Thirdly, internal democracy challenge. Parties must fix their constitutions and dispute mechanisms. Relying endlessly on courts signals weak internal governance. The Supreme Court urging expeditious hearing at the trial court is a nudge toward faster resolution. Fourth, electoral timeline pressure. With 2027 approaching, every delay risks parties missing INEC deadlines for candidate nomination or structures. The Mark faction had highlighted the grave risk of exclusion if judgment was further delayed. Comparison. In corporate law, courts are reluctant to freeze entire companies over boardroom fights unless fraud or irreparable harm is proven. Political parties, though not exactly companies, share similarities when their business is offering governance alternatives to citizens. Balanced view. Nigerian democracy is vibrant but messy. Court interventions protect rights, yet excessive litigation can turn parties into legal battlegrounds instead of idea battlegrounds. The resources will be if all sides respect the eventual substantive outcome and refocus on policy and voter outreach. So, what happens next? Here is the likely sequence. 1. Parties return to Justice Emeka Nwete's Federal High Court for accelerated hearing on the substantive issues. 2. Evidence, arguments on the ADC constitution, compliance with Electoral Act provisions on internal democracy and justiciability will be presented. 3. The trial court delivers judgment on the merits, possibly within months, though Nigerian cases can drag. 4. Any dissatisfied party can appeal again, but time pressure from the election calendar will be intense. 5. Meanwhile, the Mark-led group can likely resume normal activities, subject to any fresh interim orders the trial court might grant. My advice to stakeholders: Prioritize unity where possible. Prolonged divisions only benefits the incumbents. Focus on building structures, recruiting members, and offering clear alternatives to Nigerians tired of the status quo. My final thoughts. Today's Supreme Court ruling is a textbook example of procedural justice in action. It removed an overbroad temporary restraint that can cause practical harm, insisted on a full fair hearing at the trial level, and restored some operational sanity to the ADC without prematurely crowning a permanent winner. In law and politics, back to the trial court often means the real hard work and the real resolution is just beginning. Whether the ADC emerges stronger, more united, or still fractured will depend on how the factions and the courts handle the remitted case. For Nigerian democracy, the lesson is clear. Strong institutions, including parties and the judiciary, need clarity, speed, and restraint to serve citizens effectively. What do you think? Does this give David Mark and Aregbesola the momentum they need, or is the uncertainty too risky for 2027? Drop your thoughts in the comments, respectively, please. Which opposition party do you see gaining ground next? If you found this breakdown helpful, hit like, subscribe, and turn on notifications so you don't miss future deep dives into Nigerian politics, court rulings, and election matters. Share this with anyone trying to understand the game beyond deadlines. Thank you for watching. Stay informed, stay objective. See you in the next one.